Good afternoon. My name is Ken Jewell. Thanks for joining me in my seminar concerning how to get through a divorce without breaking the bank. One thing I'd like everybody to keep in mind, I'm speaking from a New York law perspective because I'm licensed here in New York State. I'm not licensed in any other jurisdiction. While there is a lot of commonality between New York and other jurisdictions, to the extent that you have any questions, I would highly recommend that you reach out to your local attorney to discuss what we've discussed in terms of being able to find the right solution that works for you, and so that you also have a greater understanding concerning the divorce process. With that said, the principles that I'm ultimately going to enunciate will how do I say this? The principles that I'm going to enunciate are general and broad across all jurisdictions. The idea is to get through the process efficiently and not spend all of your hard-earned money in terms of getting to the other side of the divorce. Divorce, as we all know, is a very emotionally trying experience. People have a lot of hurt feelings. There's a lot at stake, especially if there are children involved. One is concerned whether or not their spouse is going to try and take advantage, or are they really going to sit down at the negotiating table. And depending upon what had happened in the marriage that brought the marriage to the process, to the point of divorce, will depend upon how much emotion is involved. Some people simply have come to the conclusion jointly and mutually that the marriage isn't working, and therefore they sit down and they work it out together, and they have their lawyers by their sides to make sure that they're getting a fair settlement. Other people who have, let's say, had philandering issues or alcohol and drug issues or that kind of thing may have a significantly higher amount of emotion involved as they're going through the process. And so that's one of the things that we really need to control for as we go through the divorce process. The children particularly don't need to see parents fighting and taking out their divorce issues in the household. We always want to keep that out. This is a mechanical process. In New York, we look at it as when the marriage has gone bad and the love is no longer there, that it's an economic partnership that needs to be dissolved, much like a business partnership. The law is 25, 35 years old in this state, as it is in most states. And with that, it basically means that the process is pretty much standard for almost everybody. And to drag out what could be a 6-month or a year process, or if there are a couple of issues that need to go to court that may be a 2-year process, into a 5, 6, 7, 8-year process is really unnecessary, and it only prevents you from moving on to the next level. So we ask people to keep the emotions out so that we can move along as we need to get you on the other side. In New York, we have 7 grounds for divorce. They include abandonment, adultery, cruel and inhuman treatment, living apart under a judgment of separation for at least a year, living apart under a signed separation agreement for at least a year, if your spouse happens to be in prison for at least 3 years, or an irretrievable breakdown of the marriage for at least 6 months. In New York, that means no-fault divorce. And every jurisdiction in the United States has some form of no-fault divorce. What I recommend to clients is, if you're going to spend time and money, do it in another component of the process. The idea of getting divorced means that you want to get away from this person, and to fight over the reasons why you want to get away from the person is a waste of money. If you focus on the fact that you want to get out of the marriage, and the marriage is broken and it's just no fault, and it is what it is, you have one thing to take off of your list and resolve and move forward. And that would be through no fault. And we recommend with our clients that they always take no fault, no matter how egregious or bad something may be. When we deal in divorce in our office, we always want to deal with the children first. The children look at both parents and for guidance, for support, for love, and they need to have stability. And how do you give a child stability in a divorce process? Well, the first thing you want to do is get an agreement together that lays out who the child is going to live with, who the children are going to live with, when the other parent is going to see that child, and how often and how frequently. Um, so we really want to address the child custody and visitation issues upfront so that the children have stability going forward. There are two forms of child custody. First is residential custody. Basically, what we're talking about in terms of residential custody is who are our children going to live with. Now, that can come in a couple of forms. You can have what we call a primary residential custodian, which is a parent who has greater than 50% of the time with the children. And that's the children's main home for mail, and where they keep most of their property, books, clothing, that kind of thing. And then there's also, and what happens in that scenario is that the other parent who does not have primary residential custodian has what we call liberal visitation. Liberal visitation would be at minimum every other weekend, a night or 2 nights, 3 nights during the week. And if the child is older, overnights during the week. We really want to promote, no matter how bad the divorce scenario may be, we really want to promote the child's relationship with the parents. And for those parents who decide to get involved in the other parent's ability to have visitation, that can be a game changer and a custody shift in terms of primary residential custodianship, because we want children to have a good relationship with both parents. It's proven time and again that a good parental child relationship leads to a stable life for the child as they grow up and mature. The other component in terms of custody is decision making. Decision making comes in 3 forms. We have educational. Educational decision making means what school is your child going to go to? And oftentimes that's an issue when we're talking about public school, private school, and also sometimes public school. It depends, if there's 2 schools that the kid can go to or the children could go to, parents may be having a disagreement over that. Where you have the real educational issues is the difference between one parent wanting to put the kid in public school and the other parent wanting to have the kid in private school because of the cost differential. Education also includes what summer camps the kids will attend. It'll also include tutors, things along those lines. Anything that's within the educational realm would be, or what the child is doing in order to learn, would fall into the decision-making category. Medical treatment. We're talking about whether or not a child's going to get its inoculations, when it's going to has his or her physical. And generally, this does not become an issue. The only time I have seen in my career that medical become an issue between the parents is when one parent may have a affiliation with a religious entity that doesn't believe in inoculations or believes in natural medicine or something along those lines. This is not usually something, again, that people fight over. And then there's the religious training component of decision making. For those people who are, or those couples who have relatively similar religious backgrounds, this also is a non-issue. It does pop up when you have people of 2 completely different religions. But again, in our office, what we do is we try and facilitate both parents' religious beliefs with the children, because at the end of the day, the child is the product of both parents, and it's both backgrounds that the child needs to learn and incorporate to get a better understanding of who their parents are and what their backgrounds are. Let's see, let's click on to the next slide. As I was saying beforehand, most custody battles result in the fight over educational decision making, and that's largely over cost. One parent wants to send the child to a $7,500 summer camp, and another parent wants to send the child to the $15,000 summer camp. And here again, we really need to find out what is in the best interest of the child. To the extent that parents cannot get it together and come up with an agreement where their children are concerned, a court will order certain steps to be taken, and we get into what is essentially a custody battle. And the standard is always going to be not what is in the best interest of the parents, but what is in the best interest of the children. So if the parents cannot agree, the first step that the court is going to get into is probably appoint what we call an attorney for the child or an attorney for the children. And the tragedy in that is that now your child is in, or your children is in, the divorce process. They have their own attorney. They're going to speak to their own attorney, and that attorney is going to present the child's view to the court, and it may not be consistent with either or both parents' views. The attorney for the child will also hopefully work with the attorneys for both parents to see if they can facilitate some kind of settlement. To the extent there is a period that nothing is being resolved, the court will ultimately appoint what we call a forensic psychologist or forensic psychiatrist, who is going to analyze the family system and articulate to the court what the pros in a report that can be of length or some length, that would articulate both the pros and the cons of each parent, and who and what makes them the parent for the child and what their shortfalls are, so that the court can ultimately make a decision. The forensics, as a general rule, do not make recommendations. They only state the facts. But on the other side, they do play a vital role, because they are interviewing people who have, knowledge of, and intimate knowledge of, the family system. So that can include school teachers, that can include tutors, that can include counselors, that can include a psychologist for the child, that can include a whole host of people. And the thing that people need to be aware of is that where there is generally a hearsay rule, and where you can't take what, say that somebody else said something, you want to be able to cross-examine that person and at least be able to ask them questions. In the forensic area, the forensic can include people's opinions that would otherwise be hearsay, and it's because the court believes that the forensic is capable of being able to filter out and put all the pieces together in the report to be able to portray what is exactly going on in the family system. So where hearsay in a trial would not automatically be admissible or be allowed in the forensic report, it does get included, and it can change scenarios that might not otherwise be changed if we were dealing with a straight trial. Child support is our next category, because again, this is consistent with taking care of the kids first as the divorce process proceeds. Child support comes in two categories. There is basic child support, which involves food, clothing, and shelter only. This is the basic monthly payment that one parent pays to the other. In New York, it's generally a formulaic approach, which we'll get into momentarily. And then the other component would be add-on expenses. What are add-on expenses? Add-on expenses are anything that is not food, clothing, and shelter. So we're talking about tutors. We're talking about private school. We're talking about extracurricular activities, summer camp, unreimbursed medical expenses, which we could consider co-pays, or costs that the insurance company will not cover, health insurance, and so forth. And those are prorated to each party in accordance with their income levels. As I was saying beforehand, basic child support is a formulaic approach in New York. In New York, we cap the income initially at the first $143,000 in combined parental income, and then any amount over and above the $143,000, that would keep the child in the same standard of living they would have been in, but for the fact that the parties were divorcing. Again, it's so important for people to understand that the children need to be isolated from the divorce process, and the children cannot be penalized because the parents are splitting up. It doesn't help them. It doesn't make them or help them become good citizens as they get older and mature and become part of society. In particularly downstate New York, I can talk about the idea that if you're dealing with a high net worth family and someone's making $1 million a year, the court is not going to include the entire $1 million a year, largely because even on a food, clothing, and shelter basis, the child isn't going to need $1 million at its disposal, and you don't want to create a windfall to the extent that one would be created by including too much money. We in downstate New York generally keep a lid at about $350,000, $400,000 for basic support issues, unless there is really an exception where then more money would be included. There are about 19 factors under the statute that a court will consider in terms of including additional money. Whether it depends on needs of the child in some particular respect, whatever the case may be. But there is a range that additional money will be included from the basic perspective. Also, many states, such as including New York, will take a percentage of the combined parental income, whatever the court seems to determine, and dedicate that money for child support. So if you have one child in New York, it would be 17% of the combined parental income that's included. If you have two children, it's 25%. Three children would be 29%. Four children would be 31%. And five or more children would be 35% of the combined parental income of the parents. Taking aside the fact that there is a statute in place, if the parties can negotiate a child support number that works for both of them and does not work as a penalty to the children, the courts do, and the statute does allow parents to opt out or take themselves out of the statutory scheme, provided they provide specific reasons why they think that their agreement is better than what the statute says. Those reasons could include that they wanted to stay out of court, that they are, have a particular way of wanting to finance expenses, any number of reasons. But as long as they're stated, that will be fully enforced by a court, provided it does not put the children at a disadvantage. The next component that we include and look at is spousal support. Spousal support in New York, and probably in many other jurisdictions, come in two forms. One is temporary, and the other is permanent. Temporary spousal support is support from the date a petition or an agreement, a petition is filed or an agreement is reached by the parties to the time the divorce judgment is signed by the court or a separation agreement is entered into by the parties. Permanent spousal support is anything from the date of the divorce judgment going forward for whatever specified period of time that either the statute provides or that parties can agree upon. Spousal support depends upon, in New York anyway, spousal support will depend upon whether or not there is child support being paid to the residential custodian. If there are child support payments being made up to the residential custodian or to the parent who's receiving the money, up to 25% of the moneyed spouse's income is paid to the non-moneyed spouse. If there is no child support payments being made, up to 30% of the moneyed spouse's income is paid to the non-moneyed spouse. What we're trying to do is create a scenario where there is adequate support for the spouse who's not making the kind of money that the other spouse was making, so that they can get their life in order and move on. Spousal support is tax deductible to the moneyed spouse and taxable to the non-moneyed spouse. This is an Internal Revenue Service regulation. You can change that by agreement, but it is spousal support, unlike child support, which is paid for out of after-tax revenue. Spousal support is basically viewed as a wealth shift or an income shift from the person who's earning the money to the person who's receiving it, so therefore it will be taxed at the rate that the recipient spouse would be paying taxes at, and it's deductible against the payors or the moneyed spouse's income. The length of the spousal support obligation is dependent upon the length of the marriage. Here again in New York, if your marriage is up to 15 years long, spousal support is payable to approximately 15 to 30% of the length of the marriage. If the marriage is between 16 and 20 years long, the spousal support obligation would be between 30 to 40% of the length of the marriage. And if you have a marriage where it's 20 years or longer, then your spousal support obligation would be somewhere between 35 and 50%. Keep in mind that the length of spousal support payments is guidelined by the statute. The parties are free to consider other ways of being able to pay spousal support. Oftentimes in my office, what we look at is, where is the client that we're representing? Are they in their 40s or early 50s and they're in their peak earning years? And we may want to consider just making a more of a lump sum payment as opposed to or a larger payment up front to get it over with sooner rather than later. So that the person can, move on and use their, save the money that they would otherwise be paying in spousal support for retirement or for whatever else they need. So the next component that we have is called property distribution. Property distribution, and in New York we call it equitable distribution, is the division of the party's property that was acquired during the marriage. There are two kinds of assets when we look at a property distribution scenario: marital assets and separate property assets. Separate property assets are assets that are acquired either before the date of the marriage ceremony or inherited during the marriage. What's key here is that the separate property must be titled in the name of the spouse who owns it. The minute that you include the money or the asset with the other spouse, you put the other spouse's name on it, it becomes marital property. If you deposit funds in a joint account and you leave it there for more than, let's say, 24 hours, it's going to become marital property. And now it goes through a completely different analysis. Different forms of analysis. If we talk about marital property now comes in two different kinds of categories. You have passive assets, which are assets that appreciate or depreciate, whether or not the parties put in any effort, or without the parties putting in any effort. Two examples that I could think of would be real estate or investment portfolios. You buy the house, you keep the house for 20 years. Yes, you do some maintenance on it, you maybe expand something, whatever, but ultimately the house will appreciate or depreciate because of market forces, not because one or both spouses really did anything on a day-to-day basis to cause that appreciation or the depreciation. In New York, these assets are divided down the middle 50-50. Parties are, of course, free to renegotiate the whole pot of assets from the 50-50 rule. Let's say I want to pay less spousal support, and my wife or my husband would be happier to have more of the assets themselves up front as opposed to a spousal support payment. There are multiple ways of being able to divide these assets, but if we can't agree, it goes back to being a 50-50 analysis and divided down the middle equally between the parties. Active assets, in turn, are assets that appreciate or depreciate depending upon the efforts of one or both parties. Typically, what we're thinking of are businesses and professional practices that were started during the marriage. If they were premarital, they're not, there used to be, but there no longer is an appreciation component that would be divided between the parties. In other words, if the professional practice was started beforehand, a license, for example, is no longer valued. It really does need to be something that was started during the marriage to get an active asset analysis. And in these assets, or in dividing these assets and deciding how that's going to be done, we're looking at what we call a degree of contribution analysis. And what we mean by that is, how much of a contribution did the non-owning spouse of the active asset contribute to that spouse? If they were not directly involved, but enabled the owning spouse to dedicate his or her time on that active asset, you're probably looking at a 5 to 25% payout. And when we think about someone who's not directly involved, we're talking about the spouse that stayed at home and raised the children, that managed the household, that did all the things that enabled the titled spouse to be able to make the business or the professional practice what it became. If, however, the non-titled spouse is directly involved, now we're talking about a 25 to 45% contribution, because the contribution was pretty substantial probably, or it was some kind of substance to the contribution. In that regard, we're thinking of someone who went to the asset, the business, or the professional practice, did the filing, sent the billing, did networking with the spouse, brought in business. All of these things are factors that would increase the amount of the payout to the non-titled spouse. In New York, we always give the titled spouse 10% for their personality and what they've done and what attracts people to them in order to make the business grow. But the other 90% can be, depending upon the efforts of the non-titled spouse, divided, and a payout from from the titled spouse to the non-moneyed spouse will occur. In going over all of these components, what does all of this mean for you in the divorce process? First and most important, a custody battle, when we're going to fight over the kids because we think that one parent's parenting style is not proper, the courts are generally not going to get involved in how parents parent their children. At the end of the day, there's such a different variety that as long as it doesn't give rise to abuse or create hardships for the children, courts are not really going to get in the way. And if you do get involved in a custody battle, at the end of the day, the courts are so concerned about making sure that the child has a relationship with each parent, you ultimately end up fighting over educational decisions, unless, of course, there is some kind of alcohol abuse, drug abuse, someone's in jail for a high crime, something along, that's really sort of, that stands out at the court, from the court's perspective. So we always encourage people to find some way of being able to come to an agreement. And to the extent that the parties can come to an agreement, for example, on a decision-making level, we use those three categories that I spoke about earlier in terms of educational decision-making or medical decision-making or religious decision-making. We convert those into zones of decision-making. And so one parent will have the educational decision component piece. Another parent will have the medical component piece. And maybe one of the parents will decide what the religious component piece is. And oftentimes, since medical and religion is not really an issue between the parties, most people won't really, get involved in that. If the parties are not at a point of they just really can't communicate, but they can on most levels, but there are a couple of issues here or there, one thing that we might suggest is the use of the parenting coordinator. Parenting coordinators are professionals who help parents make decisions where they otherwise can't. It's similar to a mediator. They don't have binding effect on the parties, but what they do have is influence and an ability to spell out the ramifications of each party's desire to take or make a decision in one way or the other. And they help try and facilitate something between the parties. In my office, what we oftentimes do, we will put in language that enables the parenting coordinator's recommendation to become a binding decision after a period of time. Because again, we want to make sure that we get the item closed and resolved and moving forward, because from the child's perspective, they need consistency. They need to have support. They need to know that there's been a decision made so that they can move forward and grow and do what they need to do. And we want to keep them out of the parents' divorce. And we don't want to also carry the angst from the bad marriage, from the divorce process into the post-divorce process and create bad feelings or issues for the children where the parents are concerned. Second piece, don't try and avoid child support obligations. I'm always amazed at how many parents don't want to pay the other spouse child support, or they want to pay it to the children directly, or they want to have receipts or whatever the case may be to justify the amount. Most states have an income-based analysis for child support. It's not an expense-based analysis. So your children are watching. If you're looking to cheat, chip, mitigate whatever your obligation would be to the parent because the parent is receiving it and you think the parent is misdirecting the child support to them as opposed to spending the money on the children are watching. the children will know. They may not know when they're at a young age, but when they mature and they grow up and they graduate university and they move on with their life, they always remember the parent, each parent, and what each parent was doing for them. It can make a very big difference in the relationship between the parents and the children if one parent is trying to cut the support or try and not make the payment, because the child's affected by it. So we need to make sure that we're keeping up with our child support obligations, and not creating a situation that really is a losing situation. For most courts, just to make clear, when there's an order for child support, you're stuck with that order until it's brought back to the court, or it's modified by the parties, or there's some kind of formal event that occurs. Just unilaterally reducing it will only create problems and likely bring an enforcement action. And understand that under the current law, for the last 30 years actually, that the statute of limitations in collecting unpaid child support has grown from 6 years in New York to 20 years. And many jurisdictions subscribe to the 20-year rule for child support collections. Marriage is a partnership to which each spouse both makes monetary and non-monetary contributions. What does this mean? This means that if you're going through the divorce process, even if you can't stand the spouse, you have to recognize that there was a contribution. There was something that got both of you to where you are today. And so if you're going to start fighting over and dragging out, somebody should get 80% of the assets because somebody else was a philanderer having relationships in different parts of the country with multiple people. The courts aren't really going to consider that because they can't. It's how do you create a penalty or some kind of wealth shifting event because somebody was doing something that was in the emotional or the emotionally charged person's mind egregious. It is again an economic partnership. So figure out a way to ensure that everybody gets their fair share. And if it means, giving them a little bit more to get it wrapped up, do it, because otherwise what you're doing is you're paying the lawyers and you're carrying the divorce from the bedroom to the courtroom. And that is an awfully expensive endeavor to engage in. Most importantly, always feel comfortable asking your lawyers questions about your case. Your lawyer is there to advise you. If you don't think your lawyer is giving you the proper advice, you need to speak to another attorney. You need to find out whether or not that lawyer is guiding you down the right path or the wrong path or not. And the idea of needing to hire an attorney to fight the spouse to make sure that you get your fair share, you can accomplish that same goal in a negotiating scenario. The rancor, the motion practice. Motion practice can be a very expensive course to engage in. Oftentimes you can spend $15,000, $25,000, $35,000 fighting over spousal support, child support, and visitation and all these things. Why? Unless somebody's really becoming difficult, and then if they are becoming difficult and abusive, you might want to ask for reimbursement of your attorney's fees. But overall, you need to utilize your lawyer for guidance. You need to trust your lawyer. You need to be able to even talk to your lawyer about the fees that you're being billed, because your lawyer is guiding you through that process and helping you get from the bad marriage to the post-marriage, the post-divorce life, where your life is going to improve. And remember, once you are away from that person, you now have the opportunity to move on. And so therefore, you really want the divorce process to be as short and efficient as possible. You don't want to throw away money not on things that are not going to get you the kind of return that you're looking for. So that leads me to my next point, which is always something that I have a conversation with clients over. If you have to choose between giving an asset to your spouse or paying your lawyer, unless there are circumstances that really require you to go to court and fight it out, I'd suggest that you might want to consider letting the other spouse have the asset. Because if you're paying a lawyer at $500 an hour or $600 an hour, you're racking up quite the bill to fight over something. And so, in other words, the question becomes a cost benefit analysis. How much am I paying my lawyer? And what's the value of what I'm fighting over to me if I happen to get it? If you're going to spend $50,000 in legal fees to get something that's worth $30,000, unless it's a one of a kind object that you can't get anywhere else, that doesn't make business sense. And that $50,000, again, keep in mind, that's your after tax savings. That's what you're going to live on. That's what you're going to retire on. That's what you're going to invest and have as a cushion. So you want to keep your money as much as possible. And doing that means making wise choices on how to proceed and not getting into fights that really don't do anything but enrich the lawyers and make you poor. When you end a bad marriage, you're taking a positive step, which frees you from the situation that is weighing you down. So again, thinking about how we're going to divide assets, how we're going to divide parenting time, how we're going to deal with custody. All of these things we want to make sure that we're doing in a way that's efficient, that moves the thing or moves the divorce process forward to conclusion, and gets you in a position where you can move on with your life. I'm ready to take questions if anybody has any. I really appreciate your time in terms of listening to what I'm offering in terms of how the divorce process works. Thank you.
Thanks, Ken. That was great. I'll remind everyone now, if you have a question, you can email info@savvyladies.org, or you can type your question into the chat box. And one of the questions we had come in during your presentation is, would a battle over education decisions result in custody determination?
No. Let me review the custody issues again. Custody comes in two components. You have the residential custodial piece with visitation, and then you have the decision-making piece. These two are mutually exclusive of one another. Oftentimes, particularly if you live in an environment where there's you're in, let's say, New York City, for example, you can live 4 to 6 blocks apart from one another and have a split custody arrangement. That does not get into, for example, the decision-making pieces. So, no.
Okay.
Next question.
Thank you. Okay, so the next question is, my fear is that my children's needs will be sacrificed for my future ex's benefit. What can I do about this?
Work with your spouse. Even if you can't stand that person, work with your spouse. Point out the fact that those children are looking at both of you for guidance. I'm amazed at how important it is for the parents to set aside their differences and work together for a solution for the child, and also both be actively involved in the child's life. Girls look to their father as a role model. And oftentimes what I've seen, particularly in marriages that are young or involving younger couples, is how the parent will say, gee, my father was just like my husband, or my wife was just like my mother. If the parents were involved and were playing a standard, a good role for the children would be able to make the right choices and not have, how do I say this, missing methods and ways of being able to resolve issues. So I really implore upon people to ensure that no matter how hard it may be, to remind the other spouse that the children are watching and that the children are looking for guidance, and find a way of making it work for the child. Keep in mind, again, that to the extent that it doesn't, don't go around bad-mouthing the other spouse because they're not doing the right thing. The children will know. And the children, if you are doing the right thing, the children will know that you did the right thing and the best that you could, and you'll most likely have a very loving relationship and lifelong supportive relationship with that child.
Okay, thank you. Another question we have for you, is there an online resource that allows you to do a basic calculation of how much the divorce will cost you?
That is a question that I hear all the time. The hardest part in terms of calculating the cost of a divorce is how much the parties fight over issues. If someone comes into my office with a term sheet, which basically means that all the aspects of the marriage in terms of custody, visitation, support, both spousal and child and property distribution. If they come in with a term sheet and it's just a matter of me typing up the paperwork, the divorce can be very, very, very inexpensive. But if people start fighting over, how many grains of sugar there are in the box, and now you're going to pay for a forensic analysis of how many grains of sugar, which basically means hiring a professional to count out how many grains of sugar there are in the box, you're going to spend $50,000 easily, at least in New York. You could spend even more than that. It's always helpful to be able to be straightforward and honest and sit down at the table and work out as much as you can with your spouse, and that will keep the costs down. One caution that I want to bring to everybody's attention: to the extent you hear about a flat rate divorce, keep in mind that most people will, if the case starts getting out of control and they're bound to a flat rate divorce, they're not going to get the same kind of attention in the flat rate scenario as they would in paying somebody on an hourly basis. You need to be very careful about how about an hourly basis attorney, because of course the time is always running. I oftentimes like to use the analogy of a parking meter. If you put a quarter, you get a half hour. If you're going to stay in the parking space longer, it's going to cost you more than a quarter. And the more that you fight over things, the more it's going to cost you. It really is within the parties' control to keep the cost down. And to the extent that you're dealing with a non-moneyed spouse on one side and the moneyed spouse on the other, and there tends to be a big fight, the one spouse that's driving the fight and is doing it in an abusive sense may be able to recover those legal fees based upon the fact that there's a frivolous claim being litigated just to keep the spouse, in the fold and keep the fight going. And there's also counsel fee awards from the moneyed spouse to the non-moneyed spouse. Legal fees generally are paid out of the marital pot. At least that's theoretically the idea. You're dissolving the marriage, so you want to use the marital assets to pay down the costs associated with legal representation. But again, I can't underscore this enough. It is so important for the parties to be able to work things out together to the extent that that's possible, so that you can figure out, or keep your costs low. Next question.
Okay, the next one is asking if you can talk a little bit about how to best support needs for children who are over 18.
Well, it depends. When you talk about supporting needs for children over 18, keep in mind that there are only 3 jurisdictions, New York included, where child support is payable until the child is 21. What that means is that not only are we talking about food, clothing, and shelter, but in those states, you're talking about university and college education costs. And it seems odd in practice to have the child support end at 21, because typically university educations continue until the child is 22. In my office, I strongly encourage my clients to consider paying the child support until the child has graduated university, and probably even 3 months thereafter, because you want to give your child the opportunity to find a job. And be able to become self-supporting. In those states where the child support, in the 47 states where child support ends at 18, there is no obligation to support the child beyond the 18th birthday. The payments automatically stop. And so in that instance, if there's a child who wants to go on to university, I strongly encourage the parents to support the kids while they're getting their education. The kids will never forget it. If you try and cheat your child, the child will never forget it and will hold it against you. And that's really not fair to them. Of course, if there are circumstances where the resources legitimately are not there, and the parents are doing their best with the resources that they have, that's then the child is going to have to accept that. But I really recommend for the parents to always work together and come up with a reasonable solution for the child when the child gets past the 18th birthday or the 21st birthday, so that this way the child isn't cheated. Next question.
Okay, the next one is, if separation occurs, does the money spouse need to keep the bill paying the same as it was before the separation?
What I recommend to people is that if parties separate, that they try and figure out a spousal support arrangement so that one spouse is not left out in the cold and financially desperate because they don't have the resources to support themselves. Keep in mind that in New York, the Family Court Act enables one spouse who is not being supported and has been abandoned to walk into the court, file a petition, and get a spousal support calculation. And that's enforceable as a matter of law. Yes. So it's important. I can't say that you will live the same life that you had when you were married and living under the same roof. Keep in mind that two people who live under two separate roofs or in two separate households, the costs of living are significantly more than if both parties are living in the same household. So if there is an issue concerning receiving adequate support, what I recommend is in New York, the family court is actually very helpful in terms of people who don't want to be represented by counsel or can't afford to be represented by counsel. Of course, will recommend that someone have counsel so that they understand what the parameters are and can efficiently get the spousal support award that they need taken care of. But to the extent that that is not possible, you can still go in and file your petition and get a spousal support award, regardless of whether or not you were married. Remember, one thing that I like to tell people who come into my office for prenups, when you get married, you are taking legal responsibility of your spouse. And it's reflected in the Internal Revenue Code by virtue of the fact that the income levels are increased as well as the deductions are increased. And so when you take legal responsibility for someone, you're talking about being able to make healthcare decisions for them in the event that something happens and the person becomes incapacitated. It means taking financial responsibility. Marriage, again, is a partnership. Partners divvy up the responsibilities of the household and the workplace amongst themselves so that they can each function within that unit. You may not be able to live the same kind of life that you had when you were married, but you are entitled to spousal support even if you don't have a divorce going forward. Next question.
Okay, this is a follow-up to this question that you just talked about. What if they are still both living in the marital home?
Well, you can't financially starve somebody. Your spousal support award may end up being less. Keep in mind that income earned during the marriage, unless there is a prenuptial or postnuptial agreement in place excluding income from being marital property, but income as it's earned is marital property, and it belongs to both. If it's in a joint account, each person has 100% right to that money. If one spouse is keeping that money from the other spouse, then they need to go down to family court if they want to continue the marriage, but they need to go down to family court and file for spousal support relief. To the extent that they're moving into the divorce process, of course, they need to get a spousal support award.
Okay, and this is the last question, and it's a follow-up to the question about education decisions resulting in custody determination. So the follow-up is regarding final say for decisions. The spouse objecting fears I will insist on private school when the children have never been in private school, and I know that we can't afford it. But the objecting spouse is not involved in day-to-day living. It seems reasonable. Could you just talk a little bit about that?
Well, neither parent can impose a decision in terms of the children on the other. When we say joint, we mean joint, and there needs to be mutual assent or mutual agreement. If one person wants to have sole decision making you either have to do that by agreement or you need to do that by court order. If the spouse who's not involved is suddenly wanting to send the kid to private school, um, and that's the earning spouse, then that earning spouse can pay the bill. And that's in large part what most courts are going to turn around and say. If it's, and generally that scenario will paint itself out in where the couple living together had agreed to put the child in private school or the children in private school. And then in the divorce process, it's quite clear that the parties can't afford to continue that kind of expense. Where one child will, or where one parent will want the children to continue in the private school scenario. Usually it's a non-money person, and the money person who's seeing the writing on the wall is saying, we can't afford this. The courts will, unless it's pretty clear that the parties can't afford it, it's what we call a find the money analysis. If you were able to find the money to do it during the marriage, it's more than likely that you're going to be able to find the money when they're what do you call it, after the marriage has been dissolved. Um, the courts will want to continue the private school largely because that's what is in the kid's life, and you want to keep the kid's life consistent, notwithstanding the divorce. In your scenario, if the kid is already enrolled in public school and is matriculating in public school, and there's no reason to take them out, and it's working for them, the court's not going to sit here and say, oh, gee, you have to put them in private school, because that's not going to be in their best interest. Their friends are in the school that they're in now. The environment is very familiar to them. The teachers, they know what to expect. It's an environment that is clearly one that the child is accustomed to. So I guess in your scenario, what I would suggest is that if your spouse wants to put the child in or the children in private school and is also the earning spouse, the courts are going to probably look at them and say, well, if you want to do it, then you have to pay for it. But this is a very fact-sensitive analysis, and I do ask that you do speak with an attorney and have a consultation with them to really find out where specifically your case falls. Since
Okay.
that was the last question, one thing I again want to remind everybody, much of what I've talked about is New York based because that's where I'm licensed. If you are not from New York, I am asking you to please consult with counsel in your jurisdiction to find out how the law works in your jurisdiction. The laws generally are very much similar from state to state, but there are a lot of distinctions, and different courts have, and different jurisdictions have different analyses that they've enacted or put together to come out with a conclusion that they think is fair and just. And to that end, even if you are a New York resident and you're listening to me, understand that what I'm giving you are general responses and the general ways in which the rules work. Divorce is a very fact-intensive analysis. It requires a real overview of your specific facts and circumstances, finances, the way that the marriage has been conducted, the way the living arrangement is with the children. And so to get specific legal advice that works for you, I would ask that you consider reaching out to a lawyer in New York or whatever jurisdiction that you're in to discuss your case. Many lawyers do give free consultations. To the extent that they are charging for the consultation, it's worth it. The knowledge that you can acquire from sitting in a lawyer's office for an hour to an hour and a half about your case is huge, and it really helps you understand how your case will unfold or how it needs to unfold. I know after an initial consult how someone's case is going to play out and what they're going to end up with in a general sense. Of course, I can't give you specific numbers to the exact penny, but I can give you a real range in terms of where you're going to fall, and you're going to figure out what you need to fight over and what you don't need to fight over, to the extent you need to fight over anything. I really thank everybody for dialing in and listening to what I have to say. To the extent you have any further questions or you want to speak to me individually, my contact information is on the screen. Again, thanks very much, and I hope you have a wonderful afternoon.
Thanks so much, Ken. It was great.
Thank you.